Supreme Court declines to block Texas restriction abortion law, dealing a blow to Roe v. Wade. The controversial law allows private citizens to enforce the ban through lawsuits against abortion providers or others who help women get the procedure. A divided Supreme Court late Wednesday declined to block a restrictive Texas law banning abortions after fetal cardiac activity can be detected or as early as 6 weeks into pregnancy, and allowing anyone in the U.S. to sue abortion providers or others who help women to get the procedures after that time frame. The votes were 3-4, with Chief Justice John Roberts dissenting alongside the three liberal justices Elliot Gates, Stephen Breyer, and Sonia Sotomayor. Each wrote a separate opinion opposing the majority decision. The lack of action by the nation's high court deals about a blow to Roe v. Wade. The landmark 1973 Supreme Court ruling that legalized abortion nationally, essentially legalizing the law's language, incentivizing private litigation to cripple abortion care and support services. The law, known as Senate Bill 8, went into effect at midnight Wednesday after the Supreme Court did not take immediate action to block it. Abortion rights advocates say the measures is the most restrictive anti-abortion law to go into effect in the U.S. in years, with provisions that amount to a near total ban on abortion in the state. Abortion providers in Texas filed an emergency request Monday asking the Supreme Court to block the law, saying the measure would immediately and catastrophically reduce abortion access in Texas, barring care for at least 85% of Texas abortion patients, those who are 6 weeks pregnant or greater, and likely forcing many abortion clinics ultimately to close. The plaintiffs, led by the Center for Reproductive Rights, Planned Parenthood Federation of America, and the American Civil Liberties Union, and including multiple Texas abortion providers, filed the request of the Supreme Court after the Fifth U.S. Circuit Court appeal had refused to block enforcement of the law. Texas law banned abortion after fetal cardiac activities is detected, which occurs as early as 6 weeks into pregnancy, before many women even know they are pregnant. Unlike other state anti-abortion laws, Texas' unique ban is enforced through private citizens' lawsuits against abortion providers rather than those state governments. The law includes first-of-its-kind language that allows anyone, even though outside the state, to sue abortion providers or others who help women get abortion after the 6-week limit and seek $10,000 per defendant. Targets of the lawsuit could include not only organizations that help pay for abortions and practical support groups that provide women in need with transportation, lodging, recovering care, and child care, but also doctors, nurses, and domestic violence counselors, and even friends, parents, spouses, and clergy members who give aid, such as driving a woman to a clinic or providing counseling about whether to have a procedure. Abortion groups that provide those services say the law would cripple their ability to operate by allowing abortion opponents to flood the courts with lawsuits to harass doctors, counselors, and family and friends of those seeking the procedure. Abortion advocates have said the lawsuit is unconstitutional. Prior landmark ruling by the Supreme Court made it illegal for states to ban abortion before a fetus is viable, what generally happens at about 24 weeks of pregnancy. But SB 8 were designed to not criminalize abortion outright after 6 weeks, allowing the law to evade that standard. Rather, critics say it was written to incentivize civil lawsuits at the multiple counties and state levels, litigation that abortion supporters would have to pay potentially crippling costs to defend again, regardless of the outcome of the cases. That language also makes it difficult for abortion care advocates to fight back against the law implementation. For example, with a traditional ban enforced by the state government, plaintiffs would sue the law enforcement entities to block the law from going into effect. In this case, because the law is enforced by lawsuits from private citizens, plaintiffs have resorted to suing a large number of state and local courts in hopes of blocking the suits from being filed. Experts say numerous loopholes could still exist that would allow anti-abortion lawsuits under the state law. The law is also requiredly designed to put defendants at a financial disadvantage, requiring them to pay their own as well as the plaintiff's legal fees if the latter should win. And all damages, meanwhile, would go right into plaintiff's pocket, and though thought to be helping women get abortion care could be sued multiple times by different parties.